a big day, a day to learn and think about estate tax planning, community property trusts, which are very interesting, and other topics, which means I can talk about just anything I want to. So, by the way, if you're going to happen to be in Naples, Florida on Friday, October 8th, please join me for a personal goal, productivity, and acceleration of career workshop. This is being given for the law students at Ave Maria Law School, which is a great law school, and for alumni. So, but if you want to be a guest, just send me an email. And the COVID permitting, this will be a 5-hour interactive event. I've given a lot of these for different law schools and really appreciate them. Now, I just got assigned a topic that I'm really looking forward to, the Sidney Kess New York Estate Tax and Financial Planning Conference, the 19th and the 20th. I'm going to talk about charitable giving techniques as applied to real estate investors and developers. That is one of Sid's favorite topics. If you have anything you want me to talk about relating to that, please do consider signing up for this program. It's a good one. It's for the United Jewish Appeal Federation of New York. And it's hard to believe that New Yorkers want a Floridian to come up and tell them about the law, but I'm going to go up there and say, this is how we do it in Florida. That's the right way to do it. Now, Notre Dame is a virtual program this year, and it's going to be another amazing program because the materials and the authors are beyond what's available at any other program, thanks to Professor Jerry Hesch, who calls people and says, you're speaking on this because the world needs you to speak on this. Yes, I know you haven't spoken on this before. You better start learning. So Brandon and Christy Nicolo, my partners, will be speaking on the 20th on SLATs. One of your attachments today is an article that we put in Bloomberg Tax with Christopher Denicolo called Slatopedia, but they'll be talking for 2 hours there on the 20th. And then Jonathan Blotmacher and I will talk about tools and strategies to avoid ethical issues in estate planning. And sometime before then, I'll do a Saturday talk on tools and strategies to avoid ethical issues in estate planning, just as a warm up. So I have the literacy test language beginning at page 14 of your handout. And I thought that I would cover it instead of by going through the questions of what is the exemption? It's 11,700,000 per person. What is the annual exclusion that you can gift every year that doesn't count against your exemption? 15,000 a person. How much is the gift tax exclusion? Right now, 11,700,000 per person. Bernie Sanders wanted to bring that down to $1 million lifetime per person. I hope that doesn't happen. What's the portability allowance? Well, if I die, Marcia is going to be sad that she lost me, but happy to get what's left of my 11,700,000 portability allowance, unless the tax law changes before I pass away to take away the portability allowance, or it may get reduced. So we'll see. And then what's a credit shelter trust? Well, on death, the amount that can pass estate tax free, instead of giving it to your spouse who doesn't deserve it at all, you can give it to a trust where your spouse could be the beneficiary of the trust, have the right to receive what's necessary for his or her health, education, and maintenance, protected from that next spouse who you don't even know yet, probably. Maybe you do know that next spouse, you just don't realize it's going to be the next spouse, he or she, and then it's locked up for the children who may or may not be deserving, depending upon what your family situation is. So the federal estate tax exemption is right now 11,700,000. It adjusts for inflation annually with what they call chained inflation, which has nothing to do with S&M. It's a little bit slower than regular inflation. And then C, it's scheduled to go to 1/2 of what it would otherwise be January 1st, 2026. And D, all of the above. And the right answer is always all of the above. So number 6, please don't provide in your trust that when mom and dad are gone, everything goes outright to the child if she's reached age 45. Have it go in trust for life, so it never has to be subject to estate tax or creditor claims or divorce claims at her level. Number 7, irrevocable life insurance trust takes life insurance out of the estate. even if you don't expect to have an estate tax issue, consider a life insurance trust. So let's do a real live example. The exciting story of Bob and Mary Sample. You see here them on the left. They have $1,500,000 house. If it's in California, it's probably a 1-bedroom, 1-bath within 6 blocks of the water. It's growing at 303%. Well, let's say it's going to grow at 3.53%. Then they have investments of $8,750,000. The growth rate on those investments, let's put at, let's see here. Let's put that growth rate at 8.98% because they've got a thriving business, and they pay taxes of 1.5% of that. They're able to save, let's say, $400,000 a year, which is good. They earn a lot of money. But then once Mary dies, we expect that Bob will spend actually $100,000 a year more than he saves. And we're going to assume that the lifetime exemption is going to go down to half in 2026 by checking that box. We're going to assume that they will have a portability allowance, so we don't check that box. The maximum amount that can go in the credit shelter trust based on this scenario is $15.6 million. They already have $250,000 in a gift trust. They have the ability to gift, let's give them 6 children and grandchildren. They have the ability, and they can gift discounted partner LLC interest using a 30% discount, no life insurance, and they're going to maybe do a gift of $750,000 into a trust as a seed capital gift, and then they're going to put another $4.5 million. Well, let's make it bigger. They're going to put another $6 million into an LLC and sell the LLC interest based on a 35% discount for $3,900,000 note. Does anyone know what I'm talking about? Okay. Now, here's what happens. First, they both die this year, no planning. I click that, and there's no tax. Remember, the house is worth $1.5 million. Investments are worth $8,750,000. They're going to add $400,000 a year until the first death in year 1. When Bob dies, there's no tax, and everything is under the exemption amount, so there's no tax. The children get $11,357,000. They're sad they lost their parents, but happy that they can retire. So now, what happens if they live a few years? And we have them, we're knocking Bob off in 10 years. By then, the house is worth $2.1 million. The investments are worth $24 million. They do no planning, but Mary has the portability allowance. So she has $22 million on her death. There's that portability allowance. The estate tax is only $5.7 million. But what if the exemption goes down to half in 2026? I will click that little box there, and oops, that estate tax goes to $13 million. Oh, and what happens if Mary remarries a spouse who leaves everything to his children and is wealthy and dies before Mary? Then the estate tax is $16 million. So a little bit of planning in order. How about if we do a credit shelter trust, also known as a bypass trust, which has nothing to do with Bob's heart? Okay. Going from no planning at $16 million to the bypass trust, which is funded with $7,830,000 on the first death. It's worth $16 million by the time Mary dies, bringing the estate tax down to $9.7 million. Now, if I want to change a scenario, you may say, well, the growth rate's way too high. Let's go from 8.98% to 6.98%. Well, now the tax is a little bit less. Okay, then they do the annual gifting for those 6 lovely children at $15,000 a year. And what does that do? That creates a gifting trust here, which, look at this, annual gifts of $180,000 a year, using a 30% discount, gifting LLC interest. They get $3.3 million in that gift trust. that really brings the estate tax way down. They don't have to do much more. In fact, this is just gifting cash. If they gifted discounted partner LLC interest, that brings the estate tax down to $321,000. Now, they may want to get life insurance, but I did not put them in life insurance here. But then if they do that installment sale I talked about, they put $750,000 in a trust, and then they sell an LLC interest to the trust. That gets the estate tax down to zero. But let's say that they forgot to tell you about a $5 million asset, which often happens. So I'll move the assets up to 14 million, up to 15 million. Now, even after that installment sale, they have a $2,800,000 estate tax. So what do? We'll increase that seed capital gift to 2 million. We'll increase the installment sale to 10 million inside the LLC. Now there's no estate tax. The children get $53 million estate tax free. Looking at it a slightly different way, this shows you every year. The blue is not Viagra. The blue is what's in the installment sale trust every year. The red is what's in the gifting trust. The yellow is the bypass trust. The personal residence is dark green. The other assets are light green, and the red is the estate tax. See, we saw that as here there would be no estate tax, but now we see that if the second death is in 2035, there is an estate tax. That red is the estate tax each year. So what am I going to do? I'm going to increase the installment sale even more. I'm going to keep increasing the installment sale until I don't have any more red. And now every year, based on these numbers, they will not be subject to estate tax. Now you may say, I'd like to move his date of death back. All right, all I have to do is take that line. Oops, it's not working today. Well, I can take her death back to make sure that it's basically stress test. I could even take her death and have her die before him, which would make him and his girlfriend happier. So that is basically how the estate tax works. Now, if you use the estate view software, which I send for free to any client who wants it, and it's like, I think $80 for those who don't want it or who are not clients. The other thing I can do now is I'll move that date of birth there. Okay, I generate the client letter. So I click on generate client letter, and a Word version comes up, and the letter explains all the inputs and the various planning scenarios. This is not perfect, which is why we sell it for $79. It's cost me way more than $79,000 to develop this, but it's been a great hobby, and it was less expensive than our boat was. Let's go ahead and continue with our talk here. Page 18, and this is where we start talking about community property. If you live in most of the states in the United States, most notably other than California and Texas, then you live in a state where what I own is mine, what Marcia owns is hers. Even though she thinks she owns my assets, I actually own them. And if I die, I get a new income tax basis for my assets. So I have a law practice, the stock in the law practice, it has a basis of $100,000. The law practice is worth $400,000. So when I die, Marcia could sell it for $425,000 and only pay the capital gains tax on $25,000. But if we lived in a community property state, and if this was community property, even though in California or Texas, my law firm would have to be owned by me individually, when I die or when Marcia dies, it's considered to be community property, and it gets a full step up in income tax basis. So that's the good news about community property. And now, of course, you're going to say, what's the bad news? And the bad news for you estate planners is you have to learn about community property, and it's really, really complicated. One of my handouts is a Lineberg article that we published, I think about a month and a half ago, on community property trust planning. It has a lot of this information. I'm working on a white paper. It's much more extensive and involves some comments and advice that I got from Jonathan Blotmacher. I'll be glad to share it with anybody if you want to just send me an email that says white paper. Just remember, if you read it, it could hurt you because it's very complicated, unfortunately. But here's the question. If Marcia and I live in Texas, then do we want community property? Because then if one of us dies, we get a full step up for all these assets, whether I own them or she does. Or are we concerned with the creditor problem of community property? And the creditor problem of community property is that when a creditor is owed money by one spouse, the creditor can reach all the community property. So Marcia gets in a car accident, somebody sues her because they could never play the violin again, and now they come and take my law practice if it is a community property asset. We're going to talk more about this, but that is an introduction to the conversation. Now, number 9, we want our clients who are possibly estate taxable to have all the assets possible under limited liabilities, limited partnerships, or other entities that provide discounting and freezing potential. So clients come to me and I say, okay, you've got $8 million in the Schwab account. That's fantastic. Congratulations for getting that up to $8 million. If you had put it in stocks over the years, it would be $24 million, but that's a different story. I'm glad it's $8 million. When you die, do you want it to be worth $8 million? Not really. And in fact, if you die and it's gone up to $12 million, do you want it to be worth $12 million? No, because then you'll pay estate tax, silly. So what if you put that in an LLC, and the LLC was owned 99% by you and 1% by a trust for your daughter, and the trustee for the trust for your daughter has the right to decide if and when there will be liquidations or distributions from that LLC. Now, what's that 99% LLC interest worth? A heck of a lot less than $8 million. Probably more like $5,600,000, which is 70% of $8 million. The discount rate we use is usually determined by a valuation expert based upon all the circumstances of the LLC entity. The valuation expert looks at the operating agreement, looks at the investments, looks at the business and intentions of the client, and comes up with a discount rate. If you wanted to go ahead and put $15 million worth of investments into an LLC and give the 99% non-voting member interest to your child or a trust for your child, a valuation expert would probably tell you that that 99% interest is worth less than $15 million, worth less than $11,700,000. You file a gift tax return, you've gotten 99% of $15 million out of your estate without using your entire $11 million exemption. What if the IRS audits you? If the IRS audits you, they will ask for gift tax, but you will counter, number 1, that the discount you took is genuine and appropriate, and number 2, that your lawyer used a formula clause, which didn't say, I hereby give 99%. It says, I hereby give a percentage of this LLC equal in value to $10 million or less. And if it turns out that this LLC interest is worth more than $10 million, then the gift is reduced by a fraction, the numerator of which is everything over 10 million, and the denominator is the value. And that is called a wandering clause, not because we're all wondering how to use it, or that it has to do with your laundry. It's wandering laundry, wandering. And that's what happened in the Wandry case. And then there's been one case since where a tax court judge said, yeah, that ought to work. So That's the literacy test on LLCs. Gifts to irrevocable trusts. First of all, forget the tax. It is almost insane to give assets outright to a child, no matter how old they are, because of the creditor issues, because of the marital issues, because of the doing things not so smartly issues, because of ruining their life journey because they don't have any reason to work anymore. For all those reasons, in addition to the tax reasons, please think 3, 4, 5, 6, 7, 8 times. If you're in base 12, think 12 times before you give assets directly to a child or anyone you care about. If you don't care about the child and you want to hurt them, then follow Robert Heinlein's advice. If you want to ruin your child's life, make it easy. So I would much rather inherit as trustee of a trust where in the trust are the assets I inherited. And I have the right to receive what I need for health, education, and maintenance. My creditors can't reach in. My spouse can't reach in. My Medicaid can't reach in and deny me access to Medicaid. If I have to have a co-trustee, then I can't screw it up even if I want to, because the co-trustee will stop that. So that is assets under irrevocable trusts. Okay, and then many of you this weekend will be gambling and drinking, but hopefully not with dementia. And I'm not sure how to spell dementia, but I don't think that's how you spell it. Okay, now, what do I mean here on page 20? Don't be the Titanic or F. Lee Bailey. Well, for those of you who are in the newer generations, the Titanic was a boat that would never, ever sink because it had lots of airtight compartments, and it hit an iceberg and it sank. So advanced planning is a good idea, and don't put all your eggs on one boat. A lot of people, a lot of families got lost on the Titanic. Now, what about F. Lee Bailey? Well, he was one of my heroes when I was in junior high. I read his book called The Defense Never Rests, and it told about how going the extra mile in investigative research, witness interviews, that he solved a lot of murder issues, getting his clients off of the murder. But then he did something that book said over and over again not to do. It said, anyone who acts as their own lawyer has a fool for a client. He said that at least 6 times in the book. All right, well, he later did some financial structuring, broke the law, and went to jail. He didn't have a lawyer representing him when he did the financial structuring. So please talk to your CPA, talk to your tax lawyer, make sure they have a lot of experience in this area before you put all your assets into a structure. We see there are people who couldn't get through law school who are great marketers, and they have companies that approach you and they call themselves tax engineers, or they go to doctor conferences and they call themselves asset protection experts. They couldn't pass the bar, so they are asset protection experts, and we've had to unwind a lot of their work. It's not always pleasant. Okay, so we have a chart here on page 21 about how the first dying spouse would have a revocable trust, and the credit shelter trust gets funded on the first death. You can use these charts. Oh, I've got another polling question. By the way, thanks to Matt Poling, P-O-L-I-N-G, a great real estate lawyer in Tampa who has helped me a few times and didn't bill me for the last conversation. So thank you to Matt Poling, 813-223-7474. Okay, which of the following are true about grantor trusts? A grantor trust is a trust that I set up for other people, but I'm the grantor, also known as the settlor. And let's say I keep the right to replace trust assets with assets of equal value. Therefore, under the Internal Revenue Code, that trust is disregarded for income tax purposes. I could sell it assets, I could buy assets from it, I could receive interest payments from it, I could pay rent to it. None of that goes on the income tax return because it's all disregarded for income tax purposes. Its income is my income. It's like a marriage, but you don't have to get along with it. It doesn't talk. You don't have to take it to dinner and buy it wine. It's a grantor trust. Which of the following are true? Number one, if you're married, it's a good idea to use food and wine as inducement for love. Secondly, transactions between a trust and a grantor are disregarded if it's a grantor trust. B, the grantor pays the income taxes for the trust. The trust doesn't even file an income tax return, so it saves money. C, proposed legislation by Bernie Sanders would negatively impact the use of a grantor trust, except they would be grandfathered if they already existed when the law passes. And D, all of the above. And the answer is D, including the part about dinner and wine. All right, so that is a polling question. Now, we will often have a client who has $8 million in an LLC, not married, and has a child. And we want a multiple member LLC because one, we want that discount I talked about. And two, if somebody gets a judgment against the client, in most states, they can't reach into a multiple member LLC. So it would be to some extent creditor protected, subject to what we call the charging order protection, which has nothing to do with batteries. So I will often set up a trust. The client sets up an irrevocable trust for the children and donates 3% ownership of the LLC to the trust. The trustee of the trust is the client's best friend. The client needs the trustee's permission to take anything out of the LLC, but has the right to replace the trustee. The client has the right to replace trust assets with assets of equal value. Now, the LLC still doesn't have to file an income tax return, but provides the estate tax avoidance because of annual gifting you can do and because of discounting. So that takes us to what can you do between the client and the trust. I used to love the definition of a preposition in grade school. I didn't understand prepositions until the teacher said a preposition is anything a squirrel could do to a tree. So it could go over the tree, under the tree, around the tree, below the tree. Those are all things that a squirrel can do to a tree. Now this is a G-rated presentation, so the definition works. But here on the left-hand side, we have the client. On the right-hand side, we have the trust. Maybe someday we'll put a picture of a squirrel and a tree. No one will know what we're talking about. But you can use a low interest rate loan between the client and the trust. So we have a demonstration of that. I'm going to skip that demonstration. I might come back to it later. Let's go now to, and by the way, the demonstration here, if you have an estate taxable estate and you think you just want to give away that 11 million and leave the rest outside of LLCs that will grow and be in your estate, then read our example here because it's a good one. Oops, another polling question. What is a GST exempt trust? And this is good because a lot of people ask about GST trusts. It stands for a generation skipping tax exempt trust. What is that? That's a trust that benefits somebody and is not subject to estate tax when they die. So I have not only an $11,700,000 estate tax exemption, I have an $11,700,000 GST tax exemption. And it's not portable. If I die and haven't used it, it's wasted. So I could put $11,700,000 into a trust to benefit my daughter, Nicole, for her lifetime, and it may grow to be worth $40 million by the time she dies, and when she dies, it will not be subject to estate tax in her estate, and she could leave that trust, if properly drafted, to her daughter, and her daughter would then have it for her lifetime, not subject to estate tax, which is why a lot of families are putting their trusts in Florida, 360 years permitted, Nevada, 365 years permitted, South Dakota, 999 years permitted. So that is what a GST exempt trust is. It stands for Generation Skipping Tax Exempt Trust. It has the GST exemption allocated to it, part of that 11.7. It's not subject to estate tax, all of the above. If you have a large irrevocable trust, you need to have someone who understands it take a look to make sure that it's GST exempt. And if it's not, there's ways that you can go to court or modify the trust or decant it into another trust. So when you're drinking wine and you're thinking about decanting it, I want you to think about trusts and how much less you can put in a trust now based upon the bottle of wine cost. So here we are for the part of the presentation you have been waiting for. And that is, no, it's not the end. I'm sorry to disappoint you. It's the married couple's trust decision chart. I mean, you think it's hard to decide whether you want a vacation home or a car or a new car or a boat, or when you're going to refurnish and replace the floors and all that. Well, how about this decision? What kind of trust should you have? Isn't that more important? So going from left to right, you know, even though it is the Sabbath, I could go from right to left, but I'm not going to do that. I'm going to go from left to right. So on the far left is a newfangled trust called the Gst Trust that we invented with the help of some other lawyers who were kind enough to give us credit for it, where a married couple can put assets into a joint trust, and when one spouse dies, there's a full step up of income tax basis and a full funding of a credit shelter trust. So the vast majority of people who do estate tax planning have one trust for the spouse one and one trust for spouse two. And whoever dies first, that trust locks up, but that trust may not have 11.7 million. And then when you do it that way, the assets of spouse two don't get a step up when spouse one dies. With the joint exempt step up trust, if properly drafted, we believe, this isn't an absolute opinion, the IRS may disagree, but we believe that there is plenty of support for the proposition, not a preposition, a proposition, that you get a full step up and the ability to fully fund the credit shelter trust. So if the married couple only has 15 million in assets and you put 15 million in the joint trust, one dies, 11.7 million goes in that credit shelter trust, and that's based on IRS technical advice memorandum and some private letter rulings. By the way, you can have the same effect with separate trusts for each spouse if each spouse has a special power of appointment over the other spouse's trust. And that is in our Gst Trust articles. If you search on Google Gassman, Gst Trust, you'll see the two-part estate planning magazine article from, I think, 2013. And surprisingly, we have not had to update that article. The law that it was based upon has not changed. So that's the Gst Trust. And the other nice thing about the Gst Trust is that I could own 10% of the Gst Trust, Marcia could own 90%. And then if I get sued because I'm a bad driver or because of a legal malpractice type of thing, then they could only take 10% of the Gst Trust. Even though if I die first, you're going to have a full lockup of the 11.7 million. So that's the Gst Trust. Now, the next thing is, and that works in all 50 states, and we're doing one in Guam. So it even works in Guam. Okay. Now, tenancy by the Entireties Trust. The law of tenancy by the Entireties, I think, is fascinating. I have a chapter on the law in my book on Florida and federal estate tax planning. I'll be glad to send you the chapter on tenancy by the Entireties. When a married couple owns assets titled as tenants by the Entireties, it is if they are an artificial, fictional person. Now, we all know that happy married couples are artificial, fictional people. But what happened was in England in the 1700s, women could not own property. In fact, Martha Washington, if you read the history of the marriage of Martha and George Washington, she couldn't own property, but she had a large inheritance, and George was able to own it with her as tenants by the Entireties. So tenancy by the Entireties law says that if you sue one spouse, you can't reach the asset because it doesn't belong to that spouse, it belongs to the fictional joint entity. And that law still applies in Florida, Delaware, South Dakota, Pennsylvania, as to pure creditor protection tenancy by the Entireties, and then almost pure and almost as good in Tennessee and a few other states. So a lot of our clients who don't have large estates have us draft a tenancy by the Entireties trust. Recently, a bankruptcy judge in Orlando, and I will not mention that her name is Judge Ginneman, wrote an opinion that said that a trust would not qualify as tenancy by the Entireties assets, as a tenancy by the Entireties asset. And she was right. This particular trust on the first death was held for the surviving spouse and children, so it was inconsistent with tenancy by the Entireties. But in her ruling, she said you cannot have a tenancy by the Entireties trust. Now, I don't think she really meant that, and I've written an article about it. I'm going to write her a letter and see. But if you really want to protect a lot of assets, don't do a tenancy by the Entireties trust, do a tenancy by the Entireties LLC, and then just provide in the LLC operating agreement that it will be payable to a trust on the second death. But if you want the step up on the first death, then use a Gst Trust, which will not have the same creditor protection as tenancy by the Entireties. It's as simple as that. Okay, now, beginning July 1, 2021, you have the Florida Community Property Trust. The inventor of the Community Property Trust was Jonathan Blottmacher. He went to Alaska and convinced the state of Alaska to pass a law which says that a married couple from any state, even a state of confusion, can form an Alaska trust there. You have to have an Alaska trustee. Jonathan's company, Peak, P-E-A-K Trust Company, handles a lot of these trusts, and they have a lot of great information about it on their website. So one spouse is sick. What are you going to do? You go to Mayo or you go to Peak Trust Company first? Well, maybe go to Peak Trust Company first because they're just a phone call away. You don't have to have a reservation. Brandon Centula there is one of the brightest people I've ever met. And he'll explain how you can set up an Alaska trust, move assets to the trust, and get a full step up on the first death. So you may want to pull that plug a little earlier if you want to get that step up before they change the law doing away with step ups. And I hope they don't change that law, but they might. So after that, South Dakota came up with a community property trust, then Tennessee, then Kentucky, and then Florida. Now, Florida's community property trust law is very similar to South Dakota's, and South Dakota's is somewhat similar to Alaska's. The big impact, I think, by the Florida trust statute, quite honestly, is that more people in the United States of America know somebody in Florida who can serve as trustee. I have 60 pages of analysis as to why the Florida trust is better than Alaska and why the Alaska trust is better than Florida. But the truth of it is, when you get to the 90 percentile, they're either going to work or they're not going to work. So if your daughter's in Florida and you live in New York and you want to do a community property trust, you don't have to hire a trust company in Alaska, although that might be a better solution for you. You can just use your daughter in Florida. So the Florida Community Property Trust has one thing that's quite different than the Alaska and South Dakota Community Property Trust, and that is the Florida Community Property Trust. You put the assets in the trust, even though they are supposed to be community property, and I believe that they are because the statute says it, only half of them can be taken by a creditor in the event of death. So Jonathan says, look, almost every community property jurisdiction going back to the 1800s says that creditors can reach the whole thing. So how are you calling this community property? How do you know the IRS will accept it as community property? Now, there's another big issue. Well, let me stop. Before I talk about the other big issue. So you set up this irrevocable trust, and it can say that on the first death, half of it goes to a credit shelter trust for estate tax planning purposes, but the other half has to go to the spouse. Now, you can also provide in your Florida Community Property Trust that the assets all go to you in the event of a divorce, or all go to your spouse in the event of a divorce, or what happens more often, all goes to the lawyers in the event of a divorce. So you can agree on the dissolution of property on death. There's two other things I really like about the Community Property Trust, actually three. The first one is I get to draft them. So we like drafting them. They're pretty interesting. Secondly, it can be irrevocable, but the trustee does not have to give information or notice to anyone other than the two spouses. When I have an elderly couple as a client and they have one aggressive child, I'm afraid that child's going to take things over, or they have an aggressive housekeeper who brought them to the meeting. If I could put their assets in an irrevocable community property trust, by the Florida law, it can only benefit them during their lifetime. It cannot benefit anyone else while they're both living. And there is no need to give notice of the trust to anyone anywhere or to give them accountings. So the Florida Community Property Trust, in addition to, I believe Alaska and South Dakota have the same rules, have also those advantages. When you're working with an elderly client, you'd like to be able to diversify the investments after the first death, and you'd also like to keep them safe. So keeping them safe, the abuse of elderly Americans, which primarily comes from an aggressive family member, just gets worse and worse every year. So that's one thing I really like about the Community Property Trust. So I've got another chart here on page 35, which coincides with the fact that 35% of you are sleeping. Can the trust be converted from a former joint or individual trust to another type of joint trust? The gist, yes. If you have a joint community property trust and you want no more community property, please, because if I get sued, I don't want to lose everything. Let's transmute, that's the word of the day, transmute, Transmute, out of community property status, make it a Gst Trust, own 5% by me, 95% by my better half. I guess it's my better 95% now. That's easy, and you can do that with your California or Texas or wherever joint trust. The tenancy by the Entireties Trust, you have to be very careful before you could convert another trust into a tenancy by the entireties trust because of the rules of tenancy by the entireties. The Gst Trust is complicated to draft and it's complicated to administer on death. It really takes a lot of care. The tenancy by the entireties trust is simpler. The Florida Community Property Trust is pretty simple to draft once you've done the first one. The community property trusts need trustees in the home state that we show one of these needs to be in one of these states. The other three trusts, the trustee can be anyone. It doesn't matter where they live. It could be, as Jimmy Buffett used to say, animate, inanimate, cone head, no cone. Anyone can be the trustee of a trust. Buffett said that in the double album, You Had to Be There, released in 1976, which is one of the most delightful record albums because of his introduction of the songs. He was just having a great time at the Fox Theater in Atlanta, and so was the crowd, which shows you why he's a billionaire now, employing over 5,000 people. The Wall Street Journal says he doesn't have time for the music anymore, but he's still a great musician. Sorry to divert. Okay, so for those of you who would like to know more, I have gobs of material. Gobs is a legal word for Latin for a truckload. Internal Revenue Code section 1014B6. Now, I've not been able to read the Internal Revenue Code during this presentation yet. Here's my chance. Property which represents the surviving spouse's half of community property held by the decedent and the surviving spouse under the community property laws of any state or possession of the U.S., that's Puerto Rico and Guam, or any foreign country, which includes Spain and France and probably Germany and also South Africa, if at least half of the whole of the community property was includable in determining the value of the decedent's gross estate. That's what gives you the step up under Internal Revenue Code section 1014-6. So I've got more information about the step up conversation, about the Gst Trust and the Community Property Trust. Blottmacher and I wrote an article on this for Bloomberg years ago. If you'd like a copy of the article, just let us know. So what are the community property states? Washington, Idaho, Nevada, California, Arizona, New Mexico, Texas, and Louisiana. Isn't it interesting how they all touch? And most of them come from Spanish background. Louisiana is completely different. They use the Napoleonic Code. So you have to drink a Cavassier before you can do a community property trust in Louisiana, preferably on Bourbon Street. And then Wisconsin. Did you notice I said Wisconsin? So that's where the cheese is made. And so we've given you the community property features of all these states. And here's a polling question, having nothing to do with Matt Polling, who spells his name P-O-L-I-N-G. Community property A comes from Europe. Well, it comes from European law making its way into the United States. B allows marital assets to all be joint. Yeah, kinda. C exposes the assets to creditors. Yes. And D, always the correct answer. All of the above. Now, for those of you who, like me, who are geeky tax experts and fans, you can read all about whether the opt-in community property state systems will allow the tax treatment. Because in the 1940s, two states, Oklahoma and Oregon, passed laws which said, you know, we're not a community property state, but if you elect in, you could be community property. And they did that because back then, there was a big income tax difference between a married couple with community property and a married couple without community property. Because back in the 40s, which is when I was in grade school, before I invented the internet, back in the 40s, married couples could not file joint returns. So the bigger earner was in a higher bracket and the lower earner was in 0 bracket usually. So, but in community property states, the IRS would allow the property to be, the income to be equally split. So Oregon and Oklahoma said, okay, if you live here, you could file a form and then be community property. And the US Supreme Court, the IRS took that to the US Supreme Court, and the US Supreme Court, and I believe it was Justice Douglas, who was one of my favorite Supreme Court justices, wrote an opinion and said, no, that would be the equivalent of the assignment of income. So it's a really interesting case to read. I really like Justice Douglas. Even in the 40s, he was writing about whether trees would have standing to sue if there were environmental problems that were only hurting trees and not people. I thought that was also very interesting. Now, page 66, and I'm going to be done here in just a minute, although it'll seem longer, and that's the equivalent of 2/10 of a billable hour for a lot of you. If I own community property and I put it in a trust for my spouse, it's like she put in half of it. So before you do a SLAT, a spousal limited access trust, for somebody who lives in a community property state, make sure that you transmute out of community property and that the gift is made of only the assets of the spouse who is making the gift. There's other traps for the unwary. For example, you move from California to Florida, and then you think you have tenancy by the Entireties assets, or is it actually community property assets? It gets very confusing. And by the way, if you have joint assets that have been funded by one spouse between 1955 and 1977, you still get a full basis even if it's not community property. Don't forget that. If you've got an old account, an old joint account from before 1977, don't be so fast to move it. Okay, well, that is what I wanted to cover today. I hope that you enjoyed it. There's more information about the Gst Trust later in the slides. You can read it to yourself at night before you fall asleep, and you'll be well asleep. Thank you very much for all of your questions, comments, and suggestions, and we will see you sometime later if you're unlucky. Thanks again, and goodbye.